This is Barry Zalma speaking for Claim School Incorporated's blog, Zalma on Insurance. Today I'd like to talk about a problem that results from the waiver of UIM coverage, that is, underinsured motorist as well as uninsured motorist. And it proves to us, as did the Court of Appeal in Pennsylvania, that an insured must know what coverage he needs before he acquires insurance. He cannot buy just what he needs if he doesn't know what he needs. Progressive Direct Insurance Company appealed the order by the trial court denying its motion for summary judgment and granting the cross motion for summary judgment filed by the Appellee, Bryan D. Koch. In Bryan D. Koch, Executor of the estate of Rhea Lynn Koch, deceased, and Bryan D. Koch in his own right versus Progressive Direct Insurance Company, and August 4, 2022 decision of the Superior Court of Pennsylvania. On June 7, 2015, Bryan Koch, while driving his 2013 Harley Davidson motorcycle with his wife Rhea Lynn Koch riding with him as a passenger, their motorcycle was struck by a 1997 Ford Explorer driven by Sean Eyrick, who was later determined to be driving under the influence of alcohol when the accident occurred. Mrs. Koch was killed in the accident, and Koch suffered injuries that required the amputation of his left leg above his knee. Really serious injuries. The parties do not dispute that Eyrick was solely at fault for causing the accident. Ultimately, Koch decided to settle the claims against Eyrick for his available policy limit of $15,000 for each plaintiff. The damages that Koch sustained from his accident in relationship to the fatal injuries of his wife and the injuries he sustained in his own right exceeded the liability coverage of Eyrick, who was an underinsured motorist. At the time of the accident, Koch's motorcycle had been insured by Progressive Direct under a policy which provided a bodily injury coverage of $100,000 each person and $300,000 each accident. Koch presented a demand to Progressive Direct for bodily injury and UIM benefits. Progressive Direct refused to pay the requested UIM benefits based on its allegation that Koch had signed a waiver form rejecting UIM benefits and coverage. On September 9, 2019, Koch sued, alleging breach of contract by Progressive Direct by failing to properly and timely evaluate the claim and pay the insured's UIM policy limits. Koch claimed that he, as an individual, and the estate were each entitled to the available UIM benefits in the amount of $100,000. On February 25, 2021, Progressive Direct filed a motion for summary judgment, alleging Koch had originally rejected UIM coverage in the inception of a policy held by Progressive Halcyon Insurance Company that was issued in February of 2004 for Koch's 2002 Honda motorcycle. Progressive Direct argued that Koch's rejection of UIM coverage in 2004 was still effective and carried forward through the addition and deletion of different motorcycles to the policy, as Koch never affirmatively changed this designation, rejecting UIM coverage. Koch filed a cross motion for summary judgment, and in support of this motion, he presented evidence of a telephone conversation he had with a representative of Progressive Direct on or about August 20 of 2014, 9 months before the accident, during which he sought to purchase additional coverage for his Harley. After the conversation, Koch added uninsured motorist coverage to his policy. the Progressive Direct representative never discussed the availability of underinsured coverage, and it was not acquired. The trial court entered an order granting summary judgment in favor of Koch. As a result, the trial court concluded that the appellant had not made a knowing waiver of UIM coverage and found that the rejection of the UIM form that Koch signed in 2004 during the inception of the policy was void pursuant to the Motor Vehicle Responsibility Law. Further, the trial court determined that there is a total of $200,000 of available UIM coverage under Koch's policy in place at the time of the accident. Whether a rejection of underinsured motorist coverage made at the delivery of the policy remains valid until affirmatively changed is the first of the issues presented by Koch. Second, he asked the court to determine whether the telephone conversation between the Progressive representative and Koch discussing different coverages created a duty on behalf of Progressive to advise Koch about underinsured motorist coverage. And three, whether the trial court erred in finding that the Progressive representative's failure to offer underinsured motorist coverage to Koch required reformation of the policy to allow the underinsured motorist coverage. Now, the court reviewed the evidence and the law and stated that as an initial matter, to the extent that the trial court found that Progressive Direct's representative misled Koch when she advised him about the availability of uninsured motorist coverage but did not discuss the option of underinsured motorist coverage, Koch's complaint does not seek to find Progressive Direct liable on a theory of misrepresentation, but rather is based on a claim of breach of contract. Although the purchase of uninsured motorist and underinsured motorist coverages are optional, a Pennsylvania statute provides that the insured must be provided with specific information to explain the separate purposes of underinsured and uninsured motorist coverages, and must sign written rejection forms with certain stated language in prominent type and location in order to knowingly and voluntarily reject each type of coverage. The insured must sign and date separate forms to reject uninsured and underinsured motorist coverage. The record supports the fact that the trial court's finding that Koch signed a valid rejection of uninsured and underinsured motorist coverage form on February 14, 2004, upon the initial delivery of the Progressive Halcyon policy for his 202 Honda motorcycle. Progressive Direct presented evidence that it had consistently sent Koch policy renewals, which stated that Koch had rejected UIM coverage. After Koch had contacted Progressive Direct on August 20, 2014, and increased his coverage and purchased uninsured motorist coverage, Progressive Direct sent Koch a policy renewal on January 3, 2015, which stated that the policy now included uninsured motorist coverage in the amount of $100,000 each person and $300,000 each accident, and listed the corresponding premium for the coverage. The policy renewal listed the underinsured motorist bodily injury coverage as rejected. These coverage selections were in place at the time of the accident at issue that subsequently occurred on June 7, 2015. The language of Section 1731, the Pennsylvania statute involved, specifically provides that any individual who completes valid waiver forms rejecting UIM and UM coverages under the section is precluded from claiming liability of any person based upon inadequate information. Further, Section 1791 of the statute provides that it shall be presumed that the insured has been advised of the benefits and limits available under the chapter provided the following notice in bold print of at least 10-point type is given to the applicant at the time of application for original coverage, and no other notice or rejection shall be required. Koch executed a valid waiver of uninsured motorist and underinsured motorist benefits upon the delivery of the original policy in February of 2004. And when Koch contacted Progressive Direct on August 20, 2014 and indicated he wished to obtain more coverage, the Progressive Direct representative was not required to give Koch additional notice of a particular benefit or to obtain another UIM rejection form, because she was only obligated to acquire the coverage that the insured, Mr. Koch, requested. The relevant statutory provision applies to circumstances in which underinsured motorist coverage has been wholly waived and does not contain the same purchase requirement as set forth in Section 1738 or contain any language entitling the insured to another opportunity to waive underinsured and uninsured motorist coverage. The UIM rejection form signed by Koch at the delivery of the policy in 2004 remained and was valid such that Koch was not entitled to UIM coverage at the time of the accident. Accordingly, the Pennsylvania Appellate Court reversed the trial court's decision to grant Koch's motion for summary judgment and deny Progressive Direct's motion for summary judgment. It remanded the case back to the trial court to enter judgment on behalf of and in favor of Progressive Direct. In my opinion, some insurers believe that what they insure and those that they insure know what the insurance they need and can select or not select important coverages. Mr. Koch knew he needed protection for uninsured motorists, but did not know he needed insurance protection from underinsured motorists. The court had no choice, therefore, but to follow the statutory law of Pennsylvania and refused to allow him coverage for which he did not order, did not pay for the coverage, and had waived the right to the coverage. As much as we would like, 20/20 hindsight does not make a coverage that is not there, and no court has the right to change the contract that was entered into by the insured and the insurer. This video was adapted from my blog, Zalma on Insurance, which is available at www.zalma.com/blog, and if you subscribe, you'll get it by email as well. Thank you for your attention.